Here's a story that should make every American pause and think. When even sandwich throwing becomes a battleground for justice, we might be witnessing something much bigger than meets the eye. A Washington, D.C. grand jury just delivered a stunning blow to the Trump administration's tough-on-crime rhetoric by refusing to approve felony charges against Charles Dunn, the now infamous federal employee who hurled a Subway sandwich at an immigration officer. This decision arrives as the second major grand jury rejection in the nation's capital, creating a pattern that's impossible to ignore. But here's where it gets controversial. This isn't just about a sandwich. When I previously covered the remarkable case of Sidney Reed, whose alleged assault charges were rejected not once, not twice, but 3 separate times by different grand juries, I predicted that Dunn's case might face similar obstacles. That prediction has now materialized in spectacular fashion. Let me break down why this matters more than you might think. Grand juries operate under what lawyers call probable cause, essentially a much lower bar than the beyond reasonable doubt standard required for actual convictions. Think of it this way. If getting an indictment is like passing a pop quiz, getting a conviction is like acing your final exam. The fact that prosecutors can't even clear the pop quiz stage speaks volumes. The circumstances surrounding Dunn's arrest read like something from a political drama. According to court documents, the Justice Department employee allegedly confronted federal immigration agents, branded them as fascists, declared he didn't want them operating in my city, and then struck one officer in the chest with what officials described as a sub-style sandwich. And this is the part most people miss. The administration's response was swift and theatrical. Attorney General Pam Bondi took to social media immediately after Dunn's arrest, announcing in capital letters that he was fired and warning that anyone who touches law enforcement would face consequences. Former Fox News personality turned federal prosecutor Jeanine Pirro released a video statement claiming Dunn thought it was funny, but doesn't think it's funny today because of the felony charges. The irony here cuts deep. This administration, which has shown remarkable leniency toward January 6 defendants who violently attacked law enforcement officers, suddenly discovered zero tolerance when it came to a sandwich-wielding DOJ employee criticizing immigration enforcement. What the grand jurors were thinking remains a mystery, but their message couldn't be clearer. In a city where obtaining indictments typically requires minimal effort, leading to the famous legal quip about being able to indict a hand sandwich, these citizens looked at the evidence and said no. Dunn has unexpectedly become something of a local hero in Washington, D.C., symbolizing resistance to what many residents view as federal overreach. But the legal battle may not be over. Remember, prosecutors attempted to indict Reed 3 different times before finally settling for misdemeanor charges, which don't require grand jury approval. The Justice Department could easily pursue the same strategy with Dunn. The defense attorneys in Reed's case delivered what might be the most prescient statement of this entire saga. They expressed eagerness to present their case to a jury, confident they could clear their client's name, while noting that while prosecutors can try to concoct crimes to quiet the people, ultimately the citizens have the last word in our justice system. Those words are proving prophetic. D.C. residents, speaking through their grand jury service, appear to be echoing Dunn's alleged declaration, "I don't want you in my city." This raises uncomfortable questions that the administration would prefer to avoid. When law enforcement becomes so aggressive that ordinary citizens start rejecting even the most basic prosecutorial requests, what does that say about public trust? When a Justice Department employee feels compelled to physically confront federal agents, what does that reveal about internal tensions? But here's the most thought-provoking angle. Are these grand jury rejections representing genuine justice, or are they examples of political bias infiltrating what should be objective legal proceedings? Some might argue that D.C. juries are simply too partisan to fairly evaluate cases involving Trump administration policies. Others contend that these rejections prove the system is working exactly as intended, with citizens serving as a crucial check on prosecutorial power.
The story isn't finished.
These cases will likely continue evolving, and the outcomes could establish important precedents for how federal law enforcement operates in communities that fundamentally oppose administration policies. So, here's my question for you. When citizens consistently reject prosecutors' attempts to bring charges in cases involving resistance to federal enforcement, are they upholding justice or undermining the rule of law? And if you were on one of these grand juries, looking at the evidence about a sandwich-throwing federal employee, how would you vote? Share your thoughts, because this debate goes far beyond sandwiches and strikes at the heart of how justice should work in America.